Judge, I'm asking for the 10 years and just to give me that chance to pay back this restitution. And I just, for one time, have a normal life. I accept everything that I did. I just want to move forward. I finally have it, and I feel like everything's going to get taken away, but I do accept full responsibility, man. I do. I just want that chance to pay back, give them what they're asking for, the restitution, and just move on with my life.
Waiting for an interview for the construction business, and I don't know if I gonna get a call this week or the next week, but maybe if I be able,
All right, just 1 second. Excuse me, if you all can't whisper, then you're all gonna have to confer outside. Daniel.
if I will be able, try to look for another job, see if they do not contract me on.
All right, and so are you doing school or looking into school or anything of that nature?
Not right now, I'm looking just for a job right now.
Any type of trade school or
Also,
trade school or anything of that nature? What are you planning on doing with your future?
for a GED.
All right. So you said GED?
Mhm.
All right, have you started working towards that?
So,
Say yes, ma'am, or no, ma'am, when she asks you a question.
um, not right now, man.
All right, so it's probably best if he starts trying to get his GED if he doesn't have it.
Yes, ma'am, that's what you're working on, correct? Trying to get your GED?
Mhm.
Okay.
All right, so his GPS, what is the status of that? Is he on tracking or does he have scheduled?
I
set
think
time?
he still has a full house GPS for the first 3 or 6 months.
Mhm.
And then after that, we're gonna reevaluate, I believe, if I remember correctly.
All right, it's been 3 months.
Yes, ma'am. But I think it was 3 months, but I'm not sure. I don't want to lie to the court.
No. Because I think it's time for him not to be on full GPS.
Your Honor, Your Honor, in December, the conditions were modified for partial GPS,
Mhm.
and there's not been any violation.
All right, and so then we said partial, I believe, I guess I probably said partial for work or to look for work.
Employment and mandated classes only.
All right. So are you okay with loosening that a little bit to giving him some extra time or no?
You're right.
Yes, I do see that, we have been in communication with him in regards to, certain job fairs and so forth. He's in compliance with all of his field visits, he's reporting on time.
So I think,
Judge, if we put him on tracking, he can go out and look for other jobs. He can stop at job sites and things.
well, I think what I'll start with, because now it's just partial. I'll start with him being allowed to do things in certain hours. So if it's not work related, or if it's not for classes, I'll allow him to be out and about till 6 p.m.
Okay.
That means that you'll have to be at home at 6 p.m. Now, if you're at work and your work schedule takes you beyond 6 p.m., that's fine. So we'll start with that. And then the next time, if there are no issues, then we'll start with tracking only and then hopefully move towards removal.
So from what time to what time? I know from till 6 p.m., but what?
We'll
time?
do it Monday through what date? Do you want Monday through Friday or Monday through Sunday?
Judge, we don't have any, I would say Monday through Saturday.
All right. Monday through Saturday, we'll do 7 a.m. to 6 p.m.
6 a.m.
7 a.m. to 6
6
p.m.
a.m. to 6 p.m.
Okay, you want 6 a.m. to 6, okay.
Yes, Judge.
She's
That
fighting for
way,
you.
just because, just in case he gets a job to where he has to, you know.
All right, so your GPS now will be 6 a.m. to 6 p.m. That's whether you're looking for employment or whether you have a class or not. If you want to go to the park, then you can do that. So that's from 6 a.m. to 6 p.m. If there is something where you have employment and that employment takes you outside of that window, or a class takes you outside of that window, let probation know.
Okay, okay. Yeah, I will notify them if it takes longer than 6 p.m., sorry.
All right. So then what we'll do is we will see how that goes, and we'll come back in 3 months. And in 3 months, it'll probably, if there are no issues, then it'll probably be tracking only. And then 3 more months, if there are no issues and nobody objects, it'll probably be removal.
Good. Just yesterday, it just happened that I got a call from an old client.
Mhm.
He owns a house framing business.
Mhm.
And he had some traffic tickets, so I went to pick up the money, pay the tickets. I'm gonna call him and see if he can use it.
Okay, awesome.
Okay.
Thank you. Johnny, you're so awesome.
Well,
I've known you forever. I've known you when I was a defense attorney and a prosecutor. You're just awesome.
well, thank you. So are you. That's why I love coming here.
Oh, thank you. So Norma, on this case, if you can give me a date to come back in 3 months, April 4th or April 11th.
May I look at my phone?
Sure. Or if you want a date other than that, just let us know.
Your Honor, while he's looking at his calendar, as far as the mental health treatment is concerned, are we okay just to monitor at this point? And if
Yes.
anything arises, let the court
Yes.
know?
We'll monitor. And if there are some issues that you're having, be sure to let your attorney know and let probation know, because we can't help you if we don't know.
Okay, ma'am.
And the last thing you want to happen is something that happened, and then you come back to this court and saying that you didn't tell anybody.
Mhm.
Because in this court, I believe that communication is key. When I place people on probation, I want them to be successful. So you have no excuse. And if the probation officer, who is your probation officer, is not addressing some issue you have, you can always call your attorney, or either you can always come to court.
Right, will do, ma'am.
All right, what,
April the 4th, Your Honor.
all right, Norma, we're gonna call this back on April 4th.
First one, after you finish.
So, se consume con para ayuda psicológica, estoy en eso.
Mhm. You okay?
También the anger management, porque
Are you taking anger management?
no, es en hold. No.
Okay,
I see.
Perdón.
all right, anything else that's needed?
He's wondering about something, let me find it for me, please.
No, perdón.
Something about anger management, but I don't remember anything about anger management.
Let me see.
Yes.
I don't have anything listed on the docket sheet that he's supposed to do anger management
What is the
classes.
anger management?
It was on hold until something happens or something like that.
Oh, so it's in abeyance? All right. Bashan, he has some concerns about his conditions.
No sé si lo es.
I don't have him down for anger management, but he thinks the paperwork he's reading says that maybe it's in abeyance or something. If you could review that.
Yeah, I don't remember anything.
It's right here.
It's in it.
Yeah, have anger management held in abeyance.
All right, so yes,
That
you
was
don't have
on
to,
his original conditions.
all right, so you don't have to do that.
Not yet, you don't have to do that. That's why it says that, okay?
Mhm.
And I don't know if Johnny would like a copy of that.
This-
Yes.
Okay.
All right, is there anything else?
No, Your Honor.
I mean,
All right, thank you. Good luck
Yeah,
to
make a
you.
copy
Thank you
for
for
me.
the good work.
Thank you, Your
I'll
Honor.
put one in the
For her.
court.
Okay. Thank you. Thank you, Your
All
Honor.
right, thank you. Have a good one.
Yes, ma'am, you too.
All right, Melvin, this is John. Kelly Cottner. If you'll come forward.
We conferred, Judge.
All right. All right, so she's providing an affidavit of non-driving. So what type of device do you all want her on?
Scram, Judge.
Okay.
Now, Judge, she's currently has an ankle monitor GPS tracking. And she's under house arrest. And rather than have two monitors, we're asking that it be partial, some sort of partial house arrest so that she can take care of business and including visiting with me. Because it's time, there are time constraints. And I don't want to have to deal with that.
I'm not the one who put her on GPS. State, are you ready to address GPS issues?
Yes, Judge. In talking with Mr. Sharman, I guess the state has a number of questions. Mr. Sharman's related that she has a number of business interests, both in this county and out of county. I just wanted to maybe see if we can get more information on that before making a decision to switch to partial. And I kind of understand it's more to do with land and other litigation in other counties. Is that correct?
All right,
Yes.
then what I can tell you is I'm not going to address the issue with GPS as far as removal. But of course, with GPS, she's allowed to visit her attorney. And I will place in this order, defendant allowed to visit her attorney for legal matters. And then any other issues with GPS, you all need to file a motion and I will hear it.
I think we've already filed a motion to modify.
I think we did.
Yeah, and
Okay, I don't have that. If you want to go to back and have them pull it, State, are you ready to have that heard?
Yes, Your Honor.
All right, so if somebody will pull that motion for me, I will hear it.
okay. Get the file and bring it to.
According to him, he's never been informed that he needs to calibrate it each month. I've explained that to him today.
Okay,
also
I know
told-
he's been informed that he needs to calibrate it.
I've told him he needs to start writing things down if he's not remembering what his pretrial officer or anybody else is telling him. As far as I know, he's been testing negative for all drugs, any alcohol. He's been on random UAs the whole time. He tells me he's not drinking. So it is his third violation. The two previous violations were a delay in getting the device installed. He does not have a vehicle, so we had to appear before you to get an in-home device authorized. So he hasn't been tested positive for alcohol, Judge. I have told him there are rules that he needs to abide by, and if he can't remember them, he needs to write them down. But we're set for a plea hearing next week. I anticipate getting it disposed off of your docket. I'm asking you to keep it.
Can we get it disposed now? State is here, file is here.
I haven't reviewed the videos with him yet, Judge.
All right, if you all want to review, State, do you have the videos down here?
I get downloaded for Judge.
I have them in my possession, Judge. I'd like to review them in my office. That was the plan, was to meet with him this weekend, come back on Tuesday, let him decide if he wants to plea or go to trial on the case.
Well, we're just handling the criminal side of it right now. Is he,
No, he's going to need an immigration attorney.
okay.
So are you all retained?
Yes, we are. If the
All right.
court deems it necessary, they can go ahead and start the process.
Well, no, are you all going to pay for him to have an immigration attorney?
No, we're doing the criminal side of it. We're just doing the criminal.
No, I mean- Well, the reason why I asked is because legally, immigration issues have to be addressed with him because he cannot enter a plea without someone telling him the consequences.
Oh, yeah, yes, I'm certified as an immigration law attorney as well, Your Honor.
Okay, all right.
However, I don't think he's gonna be pleading right now.
No. I don't want anything to hold up this case. I don't
Okay.
want us to have a jury trial and we can't go because the immigration issues have not been addressed. So you're going to address the immigration issues as it relates to this case with him?
Yes, ma'am.
All right, thank you. All right, Ms. Ferguson, on Wilfredo Salinas, if I can have a 30-day reset, please.
Your Honor, I have a quick request as well.
Yes.
I didn't get information as to whether or not an amount is bail has been set
Mhm.
for Mr. Salinas. Is there any way we can get that amount set here, or do we have to set a separate hearing?
Oh, no, you just file a motion and we'll hear it if there is some bond issues. So you
Okay.
just file the motion and we'll hear it.
Okay, so I don't know if the amount set now will be considered to be an excessive amount.
Oh, if you all think that he can't pay that, then if you want to file a motion for a reduction of bond, the court will hear it.
Okay, all right.
Okay,
No
thank you.
problem.
All right, we'll come back on February 12th. And yes, and Norma, Mr. Salinas is not a US citizen, but his counsel is telling me that he will handle the immigration issues as it relates to this case.
Is that at 9?
Yes.
All right, is there anything else?
Go, Your Honor.
All right, thank you.
Maybe, excuse Your Honor.
Yes.
Okay.
Do you know, is there an ICE hold on him?
Van a hacer una moción, va a hacer una petición para que me reduzcan la fianza.
Counsel, do you know if there's an ICE hold on him?
I'm not certain whether or not there is one. I can check into it, Your Honor, and I can send it to the court coordinator.
All right, yes.
Thank you.
All right, thank you. Have a great day.
Okay, you too, Your Honor. Thank you.
May I approach your honor? Yes. Your honor. Sure. And whenever you all are ready on Cerner, just let me know.
Thank you so much.
Yes.
Thank you.
Yes, there's not.
All right, thank you. All right, state. Daniel. On Wilfredo Salinas, there's an ICE hold. So this case is gonna have to move very quickly, otherwise they're gonna take him.
Yes, sir. That solves the problem.
Yeah, some people say that solves the problem, but then some people say it just complicates things.
Is it like this swallowing the spider to get the fly?
Okay, all right, thank you. All right, are you all ready?
I think we're ready, Judge.
Okay. Who is the prosecutor on Virginia Cerna?
It's the judge. Mr. Wilkins.
All right, so Mr. DeLeon, your motions are lost in the system somewhere.
Joy.
So are you all okay with proceeding without his physical motions?
Yes, ma'am. I'm gonna give you the. Sure. Judge, can I approach this as the conditions of bond that have already been put in place?
We're gonna go on the record. Court is calling CM 114217, 114220, and 114222, State of Texas versus Virginia Cerna. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Michael DeLeon for Ms. Cerna.
And are you Ms. Cerna?
Yes, ma'am.
We are here, counsel, for a bond reduction. Is that correct?
That's correct. Just for the record, Your Honor, originally Ms. Cerna was charged with aggravated assault with a deadly weapon. Her bond was set at 15,000. That occurred early in 2023. She, in late October of 2023, picked up 3 charges of aggravated robbery, which we very much dispute. And because of those robbery charges, her original bond on aggravated assault was remanded without bond. Okay, so today we're gonna.
Just one moment. And the court will also be calling 2023 CR 5815. You may continue, counsel.
And today, Judge, we're gonna be asking that a bond be set in her aggravated assault charge, and the associated aggravated robberies are set at 75,000, which is highly excessive. Before we go to the facts of those aggravated robberies, we're gonna be asking for a bond of 10,000 each on the aggravated robberies, given the circumstances.
All right, and what bond would you be asking for on the aggravated assault?
It would be ideal to reinstate her bond at 15,000, but we will go with whatever the court wishes to do.
All right. And state, are you prepared to proceed?
Yes, ma'am. We're ready.
Any witnesses? State or defense?
I mean,
None, Your Honor. I do have, I'd like to give the court a packet. I can do it one or two ways, either, and I've shown this to Mr. Wilkins, series of pictures, and I've marked it as defense exhibit number 1. I can have my client identify it, or as an officer of the court, I can identify what those pictures are.
All right, any objections to defense exhibit number 1?
no objection, Your Honor.
All right. Then the court will set exception to evidence defendant's exhibit number 1.
And what the, if I may, Your Honor, what the court is looking at in defense exhibit number 1 is the first photos are of the 3 complainants in the case. The very first picture is Christopher Cooper, who is the biological son of my client. He was not raised by Ms. Cerna, but they are biological. And the other 2 are friends of Mr. Cooper. Additionally, you're also seeing social media posts of the various complainants and their various photos with weapons, with smoking blunts, with putting up wads of cash with those weapons as well. And lastly, there are injuries to Ms. Cerna's arm that occurred during that robbery. And we do want to address that when we get to that point. But that very last photo is a kind of fresh photo, and it's kind of hard to see in the black and white versus color, but she
Right.
was cut by one of the complainants.
The court sees defense exhibit 1 with the alleged complainant listed. The court sees what appears to be the complainants holding AK-47s and Glocks. And then the next photo appears to be the complainant, who is the defendant's son, holding cash, wearing pants that are 30 sizes too big, that are sagging. Then the next photo appears to be 2 complainants with someone with a gun, but there's no face to the person holding the gun, pointing the gun at them as they smoke blunts and photograph the person pointing the gun at them. Then the next photo appears to be someone holding a gun. And I believe that's the complainant that is listed on page 3 of defendant's exhibit number 1. And then the court sees photographs with no face. So I don't know, I'm taking you at your word saying this is your complainant, but there's no face, but it appeared there's no talking by you unless you're under oath. But I do see photographs that appear to match the mark that's on your client's arm, but again, her face is not pictured in defense exhibit number 1.
As an officer of the court, I will say that I've talked to my client. She has identified the 3 complainants, that being Jonathan, Joseph, and Christopher being the ones in the photos. And I'll also point out to the court that these photos taken from social media were my client got those while she was out on bond, and was able to forward that to me before she was taken into custody on these new aggravated robbery charges.
Okay.
Additionally, Judge, if you look at the facts and circumstances of the case, I know we're not here to litigate the entire aggravated robberies, but there's an allegation that Ms. Cerna and her husband pulled out guns after inviting her biological son and his friends over to a La Quinta to see a just under 2-year-old stepsister that was born that Mr. Christopher Cooper has never met before. Suddenly a robbery occurs allegedly with firearms by Ms. Cerna and her husband allegedly. However, if you look at the facts and circumstances again, La Quinta management throws out everybody out of the hotel. There's an argument going out in the parking lot when supposedly my client and her husband have firearms, yet somehow these complainants are hanging around in the parking lot with them when they've just been threatened with firearms. Doesn't make a lot of sense. Additionally, Ms. Cerna does have that injury to her arm. She was cut. Once again, if she had a firearm, she wouldn't be in the position to be cut by Jonathan Vidales, who is in fact, all of these are, well, actually, Jonathan and Joseph are juveniles. Mr. Cooper is, I believe, 18 years of age at the time of this event in October of last year. But the circumstances are very suspect, Judge. So without going in, and obviously this court is not going to make a judgment on the veracity if she's guilty or not guilty of those specific aggravated robbery charges. But given the circumstances for setting a bond, we believe that because of the nature of the weirdness essentially of this allegation, we're asking that bonds be set of $10,000 on the aggravated robberies, so they can be litigated down the road. And we'll see further in the future if, and this case is unindicted. These three charges have been unindicted for the past roughly 60 to 90 days. We will see if the district attorney's office will even go forward. I mean, obviously, Mr. Wilkins might know more about if they even have complainants that are going to be continuing to complain in the future. So based on that, Your Honor, and the circumstances, we're asking that a bond be set on the aggravated assault and a much lowered bond be set on the aggravated robberies. Obviously, if the court wants to do GPS, that is more than fine. We might ask the court to reduce or waive GPS fees, but if the court wishes to do that, we need more. Ms. Cerna will certainly comply with all GPS conditions.
All right, state.
Yes, Your Honor, we are asking that you double the bond on the aggravated assault deadly weapon from 15,000 to 30,000. And we're asking that on the aggravated robberies, that you keep the bonds at 75,000 each. We're also asking that she has these conditions of bond, the special conditions of bond, Judge, that I attended to the court. We're asking that you keep the GPS with full house arrest in place, no contact with the complainant witnesses in the aggravated robberies, Jonathan Vidales, Joseph Berrientos, and Christopher Cooper, a prohibition on possessing firearms. And Judge, I've previously tended to the court, the police report. I didn't mark those. I have stickers here if you'd like.
If you mark those as states exhibits 1, 2, and 3. And defense, have you had a chance to review those documents?
We have, Your Honor, no objection.
All right, then states exhibits 1, 2, and 3 are admitted. And of course, defendants exhibit number 1 is admitted. And you can tender those to the court reporter. I've reviewed those.
Okay, this one. So just
And
briefly,
I'm sorry, just so the record can be clear, those were reviewed before they were offered into evidence, and both the defense and the state requested that the court review those before they were offered into evidence.
Objection.
just real briefly, the argument, in the police report, these are very serious allegations. We're asking that the bond be set at this high, or kept at this high number in order to protect the community. The code says that you can set reasonable conditions of bond. We think under the facts alleged in this police report, these are reasonable conditions, this amount, as well as for full house arrest GPS. And if you were inclined to grant a lower amount of bond, we would still ask for the other conditions, the full house arrest GPS, Judge. But I reviewed those pictures, and I think some of the questions that maybe the court had too. You know, this is a picture. I don't really know what this is depicting. This could be an airsoft gun. This could be a real gun. These guys could be engaging in blunting, or this could be tobacco. A couple of these guys are juveniles, so they have guns in these pictures that are undated. I think we don't know when that is. I don't think any allegation that at the time of the offense, October 27th of 2023, that any of the complaining witnesses had guns at the time. That's not in any of the police reports. So, Your Honor, in order to protect the community, we are asking for those bond amounts as well as the full house arrest GPS, Your Honor.
And lastly, Judge, if I may,
Yes.
what I forgot to mention was nowhere in that police report does it say that anyone beyond the complainant said that Ms. Cerna and her husband had firearms. The hotel manager was told she had a firearm, but never saw it. So I want to be real specific about that.
And just briefly, I mean, when I was reading the police report, if you're in a hotel room, I don't typically invite the manager into the hotel room. So I don't know how he would see if there are guns or not in there.
This is as everyone was exiting, all the parties.
Okay. So is there anything else from either side?
Just a few more things. No, I'm just kidding.
All right. So I'm going to keep the previous conditions of full GPS. I'll ask that the fees be waived. For the aggravated assault with a deadly weapon, I'm going to set the bond at $25,000. And that is cause number 2023 CR 5815 and CM number 114217. The court will reduce the bond to $60,000. And that's based upon what the court has reviewed in the police report. In cause number CM 114220, the court will reduce the bond to $60,000. And in cause number CM 114222, the court will reduce the bond to $60,000. And there's to be no contact with, is your husband Ruben Cerna?
Yes, ma'am.
There's to be no contact with Ruben Cerna. All right, is there anything else?
Nothing, Your Honor. Thank you.
All right, Ms.
Oh.
Ferguson, we need a jury trial date, a quick date on this case. State, how long do you expect this trial to last?
3 days, Judge.
All right. So that means it'll probably be 2 days. The earliest date you have. All right, we'll come back with jury trial on February 6th. If you're still in custody, you will be brought over in trial dressed in whatever civilian clothing you have at the jail. If you wish to be attired in something else, you'll need to do a clothing exchange. Mr. DeLeon, if there's an issue with the clothing exchange, let the court know.
Yes, Your Honor, we thank the court.
All right, and do you know if your client will be going, if she were found guilty, do you know if she'd be going to the court for punishment or the jury?
We haven't discussed that yet, Your Honor, but probably the court.
All right, on Eric Lopez. All right, thank you. Yes,
Good morning.
good morning. Norma, on this case, when do you want to bring it back for jury trial? Daniel, this is yours. Yes,
So the court's aware, in speaking to one of the detectives involved in the case, she is currently pregnant. She did say, I think she was due in March, so if there's any time in between now and March that we can set this on.
all right, Norma, we'll need some time before March.
And-
Yes.
And then my understanding is that she's going on maternity leave for, I think, 6 to 8 weeks.
All right, when will that be?
I believe that's gonna be starting in March. It really is just kind of a rolling date because I think,
Yes.
because it just coincides with.
All right, so we're gonna come back on February 6th for jury trial.
Thank you, Judge.
Thank you, Judge.
All right, you're welcome. So you don't need to be here on the 16th.
Okay, I appreciate it. Thank you.
Pete Garcia? Oh, do you need a break? All right, just give us 1 second. I'm sorry, just a brief break. On Cerner? It is CM 114217, CM 114220, and CM 114222. And then the other cause number is 2023 CR 5815. Sure. Andrew Orozco. Andrew Orozco.
He's out here, Your Honor.
All right, come forward, please. Well, so where are we on this case?
So this case, Your Honor, was originally assigned to Mitchell Russell.
Yes.
So the court, Norma's gonna appoint me on this case, Judge, because he has pending aggravated assault with deadly weapon case
Okay.
amongst other cases. I conferred with Daniel on this matter. The state wants to reset so we can move forward on the higher offense level cases.
All right, so. Okay. All right, so can you give me a month reset? Is that enough time for everyone?
Yes. I'll leave it there.
Okay, all right.
I can do February 12th.
All right, we'll be back.
Defense counsel will be out. Remember, I don't come back until we try that case with Kathy Compton.
Yes.
I leave on the 8th, we'll be back the 18th. Then we start the trial, I think, on the 20th.
Which case are you, because are you on Eric Lopez with her or no?
No.
Angel.
Angel, okay.
Remember, the one that starts that Tuesday.
So let's put it on the same date as that.
Tuesday,
Yes.
That works.
February 20th.
All right, February 20th.
Yes, Judge. Thank you.
All right, is there anything else?
No.
All right, thank you.
Thank you, Judge.
You're welcome.
I have-
John Anthony Ramirez. Who's the attorney for John Anthony Ramirez? Dinah, you ready? Are you all ready to proceed on the motion to revoke?
Yes, Your Honor.
Court is calling 2000. Please do not talk behind the court reporter. We're on the record. If y'all will remove it to this end. Court is calling 2016 CR 6340, State of Texas versus John Anthony Ramirez. Michael, can you all move it to that end? Yes. Right. Court is calling 2016 CR 6340, State of Texas versus John Anthony Ramirez. Could I have parties announced for the record for the state?
State of Texas.
Defense.
Renee Munoz on behalf of John Ramirez.
Are you Mr. Ramirez? Going to show you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it? Are you the same John Anthony Ramirez who was placed on deferred adjudication in 2016 CR 6340 for the offense of aggravated assault with a deadly weapon on April 10th, 2017 for a period of 5 years and extended for a total of 3 years? State.
Violated condition number 5 in Bexar County, Texas. The defendant, John Anthony Ramirez, did then and there failed to report to the supervision officer as directed for the months of July and August 2023 in violation of condition number 5.
How do you plead to that? True or not true?
True.
Your Honor, state waives all the violations.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 5? Court will find violation of condition number 5 true. Is there a proposed agreement?
Yes, Your Honor, we have already confirmed probation. It's for the defendant to report twice a month for 3 months virtually or in person. Monthly UAs for the defendant to continue treatment with the Center for Healthcare Services and to comply with his medications. And that would alter an amend, and we would ask that you deny this.
All right, probation.
Your Honor, we did confirm that agreement. I'm sorry, the agreement, it's not, that is the agreement.
All right, so here's the court's issue. He's been here before me previously for not reporting. So how is this going to solve the issue? And I'm taking in consideration his mental health issues. So how is this solving the issue?
Yes, Your Honor. At first glance, I can see the court's concern. I spoke with my client and he did state that he was and is currently receiving services with the Center for Healthcare Services, Judge. He has been prescribing to them. I am receipts of a document from Jennifer Munoz, his case manager.
Mhm.
I can tender it to the court.
Yes,
the court
please.
doesn't have an issue with that. He's been under their care for the last 18 months, Your Honor. And been-
All right, you all need to whisper in the box. If you can't whisper in the box, then you can't talk in the box.
He's been reporting with them for the last 18 months and has been consistent with his appointments with them, Judge. He started off with pills, oral medications, but now he's on the injection. He takes once a month and he's now currently stabilized. I believe the issue was a little miscommunication with probation. I know that probation wanted him to try to get help at Palo Alto. My client states that he went to Palo Alto to get help and they said, we can't double up on your care. You're already seeing the Center for Healthcare Services. My client has stated that he can't afford the UAs and the probation officer essentially said, figure it out. And we are figuring out, Judge. His family's going to help contribute to that UA. So that's not going to be an issue. And I told clients that, no excuses in terms of not missing probation. If he needs to take the bus, he needs to take the earliest bus possible. So even if he misses a bus, he's on time. If he's there and they're saying they can't meet with him, to document that, to take a picture, he was there, email me, email the court. Hey, I'm here. The probation officer is not able to meet with me at this time. He's wanting to reschedule, but he has been making his appointments regularly with Center, Judge, and he has been doing well with them. So it seems like, he has a lot going on, but I'm telling him that he needs to make good on his requirements to the court and probation, that they need to meet with him, they need to see him. But his sister did furnish me that document from Center from Healthcare that he is receiving treatment, Judge. And I think he does seem stabilized to me. He does seem like he's wanting the treatment and he's already set up with the center. So we're respectfully asking the court for him to allow that. I did talk with him about the proposition before the court with meeting with probation. He has no issue going there down in person. He's gonna take the bus, he's gonna have family members take them, he's gonna establish a better communication with the probation officer. I think has a year left after all the extensions, when it's all said and done, to expire in 2025 in April, Judge. So I'm encouraging him to give this last push. He's been on probation for quite a while. I think this case originated in 2016. So he has not picked up any new number ones. He has not demonstrated any violent behavior. He's demonstrated that he does need mental health services, and he is he is taking measures to help himself in that regard, Judge. So we're asking the court respectfully.
All right, and probation, I'm assuming that you all will have access to his compliance with Center for Healthcare Services?
Your Honor, we'll ask for a release of information.
Oh, you have the release?
Yes, Judge, I filled it out
Thank
just in case we need the records from.
All right. All right, so I don't think it would be appropriate for him to have to report more often than he's currently reporting, because it seems to me the issue is his mental health. So if there's no objections, what I'll do is I'll deny the motion, alter the main conditions, and he's continue with mental health care with Center for Healthcare Services. He's you to make sure that you report monthly, you understand?
Yes, ma'am.
And you are to provide a release so that the probation will be able to see how your treatment is going for Center for Healthcare Services. The court will note for the record that that release has been signed. Is that correct, counsel?
Yes, Your Honor. We have executed that, and
All right, is there anything else?
nothing further, Judge. We greatly appreciate the court's time and consideration.
Thank you, ma'am.
All right, Mr. Ramirez, we're off the record. If there is an issue, you can always come to court and let the court know what the issue is, and we'll make sure that you're on track.
Okay.
You understand?
Yes, ma'am. I understand.
All right, good luck to you.
Thank you, ma'am, very much, ma'am.
All right, you're welcome. Philip Diller,
Morning, Your Honor.
good morning.
I just needed to approach the court. I have just conferring with the Assistant District Attorney. I had previously spoken this morning to Anna.
Mhm.
We are set on the 16th for a jury trial.
Yes.
And we were set earlier in January and the court set it for the 16th.
Yes.
Well, back in October, had a felony case in Comal County that was set for trial on the exact same day, January 16th.
Mhm.
But they make you come the Tuesday before, which was a couple days ago.
Yes.
And then I received an email from them
Mhm.
that I have to be there on Tuesday by 9:45, ready to go to trial on that case. And so I had that setting prior. And that case was set prior to when the setting was changed to the 16th. So I'm just looking for court's guidance. Do I go there? Do I tell them I can't go there?
Well, is that case in Comal County a felony?
Yes, it's a felony drug case.
All right, and how long has that case been set?
It's,
I mean, how old is that case? Because we've been trying to get a jury trial done on this.
you're right, Judge. You're right. I believe that the case, certainly the offense date for the 187th case is many, many years before this guy's case.
So what we will do is this will be set in this court on January 16th. And if you need us to, we'll call Comal County and let them know that you're here. So we will put you under the umbrella of the 187th and it will be fine.
Okay.
Yeah.
That's fair.
Sure. All right.
Thank you, Your Honor.
You're welcome.
No, have a great day.
You too. All right, are we ready on Pete Garcia? Oh, it's coming back on the 16th. It's still scheduled for trial, but we'll probably need to call Comal County on the 16th and let them know he's in trial here.
Right in the middle.
Hello, good morning. All right, I believe this is family violence.
Over here now, right?
Yes. And Mr. DeLeon, you need to go to another court for your jury trial?
Eventually, but I have another matter.
All right, whenever you're ready, let us know. Court is calling 2022 CR 6930, State of Texas versus Pete Garcia. Can I have parties announced for the record for the state?
Is that done for the state, Your Honor?
Defense?
Daniel De La Garza for the defendant.
And are you Mr. Garcia? You entered a plea on December 5th to count 1 of guilty. According to the plea bargaining agreement, punishment is to be assessed at a cap of 8 years in the prison. There's a $1,500 fine. The state is opposing your application. They're taking in consideration 2023 CR 8852 and 2023 CR 8851. And there is to be restitution, if any, to the complainants in each of those cause numbers. No contact with the complainant and Chapter 62 compliance. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections?
No, Your Honor.
No, Your Honor.
All right, are there any witnesses?
No, Your Honor.
Not from the state, Your Honor.
All right, state you are opposed.
Yes, Your Honor.
You may proceed.
Yes, Your Honor. Your Honor, the state would just like to begin when looking at the PSI, this individual had cases out of, I believe it's Manatee County, Florida, put on probation for a drug offense, 28 grams to 150 kilograms.
Just 1 second, I'm sorry. Probation?
Yes, Judge.
On this case, I don't have the PSI report in the email.
Judge, my apologies.
That's okay. Thank you. Just give me 2 minutes.
Absolutely.
Oh, okay, thanks. All right, you may proceed.
Thank you, Your Honor. This individual was placed on probation on 2 different occasions out of Manatee County, Florida, once in 2006 for 28 grams to 150 kilograms of cocaine charge. Also 2007 out of Manatee County, Florida for use of investment proceeds from racketeering. That's 2 separate instances of probation outside of the state of Texas. Within the state, within Barrett County, there was this individual was transferred to TDC and sentenced in 2019 with tampering of a government record. Also 2019, unauthorized use of a motor propelled vehicle. Again, sentenced, transferred to TDC on both of those. The victim in the credit card abuse case said in the PSI quote, "I'm not okay with probation. I want him to do time. I'm sure he will do it to someone else. I don't think probation is the solution. He will do it again. He will do this to someone else." The victim in the fraudulent use or possession of an ID case said, quote, "I'm absolutely not okay with him applying for probation. I just want him to go to jail forever if possible. He is an egregious violator of the law." So that's with respect to those 2 cases, Your Honor, that were taken into consideration. And the instant case, the indecency with a child by contact, as is mentioned in the STIPs, a short 2 or 3 sentences from the report. Juvenile Jalissa Leone told her mother that Pete Garcia fondled her breast and nipples on 10 separate occasions. She stated the incidents occurred when she was 11 years old, while Pete Garcia resided at the residence. Juvenile Jalissa Leone did tell one of the interviewers that it never went further than that, but that Pete Garcia told her, quote, "Don't tell your mother," when the incidents occurred. Your Honor, in the PSI, this would be victim number 3, Your Honor, again, with respect to the indecency. When questioned, that victim said, if you just give the state one quick moment, Your Honor. Again, victim Jaleesa Leon said, quote, I want him to take some accountability. I don't want probation for him. I suffer from really bad PTSD now because of this incident. I get scared to go to sleep because I have really bad dreams. I get scared to be alone with certain people because I never know what could happen. And Your Honor, I think the word there that of course sticks out to me from the victim in our case, the indecency, the incident case, I should say, is that accountability. And to kind of in summation, if you will, Your Honor, the final point is when the defendant, speaking to the accountability, when the defendant was questioned about why he feels he should be granted probation, he told them, quote, I need to continue with the life I was living. Well, the life he was living, Your Honor, caused all of this harm in Bexar County alone, and of course, criminal offenses stretching back over 15 years. When asked, the defendant said, quote, I don't want to talk about this right now. I wasn't consuming alcohol or drugs on the date of offense. A lack of accountability and wanting to go back to the life he lived, as if somehow not being under the influence of drugs makes any of this conduct okay, Your Honor. The state respectfully believes that this individual is not qualified or suited, again, under the eyes of the state for probation.
All right, defense.
Just briefly, Your Honor, he definitely does take accountability. He does take responsibility for what happened, and he'll be happy to tell you that if you'd like to ask him. But the point
Does he
is that
want to testify?
you want to tell the judge that you're sorry.
Here's the thing, before you begin, if you want to testify, you're going to be placed under oath and the state will have a chance to cross-examine. So do you wish to testify? All right, can you raise your right hand? Excuse me, person in the black jacket. The person in the black jacket, they need to be excused from the courtroom. They're talking to someone in the box. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor, I do.
All right, you can lower your name, or lower your hand and state your name for the record.
Pete Garcia.
All right, Mr. Garcia, just one moment. Mr. De Leon,
Yes, sure.
let me know if you need to go for your jury trial?
I really want to go that bad, but I appreciate it.
All right, just let me know. All right, we may continue. All right, defense?
Yes, Your Honor. Well, hold on. I'm gonna ask you some questions, all right? So first off, you know that you've pleaded guilty to the indecency case, right?
Yes.
And then you've taken responsibility also for the credit card theft and the fraud cases, right? For lack of a better term.
Yes, come 100%. I just want to pay back the restitution.
I'm sorry, you need to speak up.
I just want to give a chance to pay back the restitution, Your Honor. The last 3 years of my life, for once, I have a good paying job. I just signed a 30-year mortgage 8 months ago. My life is finally on track, and this incident happened in 2016, 2017. 7 years later, it came up, and I do take full responsibility of all my actions. I do.
So let me ask you, when you say all your actions, are you talking about the case that you have pleaded guilty to, the sex offense, for lack of a better term?
Yes.
And you're talking about the cases that the judge will take into consideration? You take responsibility for all that, right?
Yes.
Now let me ask you questions. Now tell the judge, when the prosecutor says go back to the lifestyle or whatever, what did you mean by that?
What I meant was, in the last 3 years, Your Honor, my life has been, me and my spouse, I have been on track. I go out for a month, I come home for a week. I've been doing that for 3 years. I finally, like I said, Your Honor, the life is what I meant was me getting my life back on track, finally living a normal life.
Now let me ask you, who is your spouse?
Jasmine Manion,
Is she here today?
yes.
I'm gonna point out for Your Honor.
Sure.
Right there in the Under Armour shirt, waving her hand. Okay, and then if you were granted probation, is that where you would go back to live?
Yes.
Okay, and let me ask you, are there minor children in that house?
None.
And you have your own children, right?
Yes, they're grown.
What do you mean by grown? How old's the youngest?
21.
Okay, and do they have children?
Yes, my son does.
Okay, now if the court will order you to have no contact with minor children, is that something that you'll abide by, first off?
Yes.
Then second of all, you're gonna have all kinds of conditions that you need to abide by such as the sex offender counseling, maintaining employment, reporting to probation? Are you gonna do all that stuff?
100% complete, yes.
And then, where are you gonna go back to work?
At Halliburton.
What's that?
It's a oil and gas company.
What do you do there?
I'm a CDL driver. I deliver frac sands.
And if your CDL license is suspended or you lose that, where would you go work at that point? Let's just say.
It's a family member that works there. I would be working as a laborer.
And then now the judge is gonna give you, can give you up to 8 years in prison or deferred adjudication for up to 10 years. What are you asking to happen?
Judge, I'm asking for the 10 years and just to give me that chance to pay back this restitution. And I just, for one time, have a normal life. I accept everything that I did. I just want to move forward. I finally have it, and I feel like everything's gonna get taken away, but I do accept full responsibility, man. I do. I just want that chance to pay back, give them what they're asking for, the restitution, and just move on with my life.
Pass the witness, Your Honor.
Right, state.
Just a couple of questions, Your Honor. Were you aware that when the complainant first outcried, the reason the outcry happened when it did is because she was having frequent and violent sexual dreams? Were you aware of that?
No, I have had no contact with them in 7 going on 8 years.
And if she hadn't had such violent dreams, there's reason to believe that she wouldn't have outcried. If she wouldn't have, would you have done something to take accountability for your actions, confess or do other actions or take other actions to take responsibility for the double-digit number of times that there was the touching of the breast with your hands?
I'm sorry, I don't understand.
And I apologize. To put it simply, if she had never outcried, would you have found a way to take accountability for your actions?
If there was something said, then of course, 100%. Would I do take accountability for my actions? And like I said, it's been almost 8 years. I have not heard anything until recently. So, of course, yes, I 100%.
No further questions, Your Honor.
All right. So I have a question for both parties with regards to the restitution amounts. One complainant says the restitution amount is 0. Mejia is saying their restitution amount is $15,000, but that $15,000, they're saying that's the money they borrowed, but that the bank reimbursed them.
That was my understanding.
So it appears that the money has been reimbursed. So I understand that there's costs because they borrowed $15,000, but then the bank reimbursed $15,000. Now I can understand maybe he's responsible for the interest on the $15,000, but the court doesn't have the interest amount for that. But, and if I'm wrong in my legal conclusion to this, I don't think he's responsible for the entirety of the $15,000 if the bank, and it appears from what I'm reading, the bank has given him back the $15,000.
Yes, Your Honor. I would agree with that. Absolutely.
So I don't have a restitution amount for that.
Yes, Your Honor. I believe that is correct. I see exactly what the court is saying, and yeah, I don't believe there would be any restitution remedy available.
Okay. All right. This is what the court is going to do. The court will deny your application. Does anybody want to speak to the cap? The court is going to find you guilty. Anyone want to speak to the cap of 8 years?
Nothing from the state, Your Honor.
Well, just Your Honor, we would ask that he, based upon the fact that he has taken responsibility and that he has, done his best to make amends for what he's done, that we ask that you hit somewhere below the cap. And I would leave that up to the court's wise judgment, but I would ask somewhere below the 8 years.
All right. All right, Mr. Garcia, I want to let you know that I read the entirety of the PSI report. I read the police report. And I've seen the ages of the complainant, the age of the complainant in this case. That's an issue for the court. You understand? All right, the court will find you guilty, sentence you to a $1,500 fine, time and money to run concurrent. Take in consideration 2023 CR 8852, 2023 CR 8851. There's to be Chapter 62 registration, no contact with the complainant and either of the cause numbers. The court will sentence you to 8 years in the prison, give you credit for any time served. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, true.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, Your Honor.
All right. So off the record, I understand that people have regrets about things that they've done in their past. And sometimes we hope that our past won't come back and bite us, right? Because you moved on with your life. I understand it as you're working. I know that that job you had was a great job. I know you have the 30-year mortgage. But when offenses and crimes happen, you have to answer for those. And at some point, what we've done catches up with us. You understand?
Yes, Your Honor.
All right. Good luck to you, okay?
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
And I'll need those dismissals. Who's here on Stephen Estrada?
Judge, I hate to do this. I don't want to do this, but he was trying to talk to me for a second. I was dealing with another case. Would you flip me one behind so I can hear what he said?
Sure.
He may not want to talk to me, but he said it's.
Okay. John Ray Perez.
Judge, that's an MTR ready at home. Judge, we're not quite ready yet. Sorry. Still looking at it.
All right. John Thomas Lyles.
Yeah, don't press on that. Judge, I'm Mr. Stroud. I'm ready after.
Thank you.
I don't believe Mr. Lyles has appeared, Judge. If the court would recall, he's rather mentally challenged. The court suggested that we reach out to mental health coordinator. I have, but I haven't had any contact since we were here a couple of weeks ago.
All right. Is he on,
On bond, but not on, I don't.
is he on a surety bond or a PR bond?
Surety bond, I believe.
It's John Lyles. And do you have any contact information for him?
He wouldn't give me anything other than a friend of his mother's, so.
All right.
And he is homeless, Judge.
All right.
Doesn't.
Court is calling 2023 CR 9074, State of Texas versus John Thomas Lyles. Can I have parties approach and announce for the record for the state?
Hank Wilkins for the state judge.
Defense?
Tony Adonis on behalf of Mr. Lyles.
All right, this hearing was scheduled at at 9 a.m. It is now 10:46 a.m. The defendant has not appeared. Counsel, do you have any idea where your client is?
I do not, Judge. I know he is homeless, but he did sign the reset notice to be here today.
All right, and this is a commercial bond state?
Your Honor, we're asking for a bond forfeiture this morning.
All right, that'll be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider. You may want to try calling the bondsman, and maybe they have contact information for him.
I'll do that. Thank you.
All right. Miguel Ugui.
Michael Ugu, Judge.
Ah, Michael, thank you. All right, today is the plea deadline date.
Judge, we received a plea offer today that may or may not change depending on the prosecutor's contact with the complainants over this week.
Judge, we're arranging for a time to speak with the complainant. I made an offer, but it's one that still, we spoke with the complainant briefly through our victim advocate, and they stated this is what I'm offering is within what they would want. I'm just gonna talk to them to see if there's gonna be that change.
All right, Ms. Ferguson, on this case, if you'll call it back for January 18th.
Thank you, Judge.
Thank you.
All right, once you sign the reset form, you're excused.
That'll be our plea deadline, Judge.
Yes.
Thank you.
And counsel, your client was late.
Judge, he stopped me as I walked in and told me that he was outside on the bench. He didn't notice the people coming in. But he knows to be inside.
Okay. All right, thank you. Are y'all ready on John Pettis or still conferring? All right. Stephen Estrada.
Judge, Mr. Estrada was kind enough to let me know that somehow they said he was exposed to COVID, so I got him a mask. That's why he's wearing a mask. I don't know if it's true or not, but anyway, that's why.
All right, so we were scheduled for jury trial. Where are we?
Judge, you made an offer. I've thoroughly discussed the offer with Mr. Estrada. I've explained the consequences of not taking the offer and that the court will not take any agreement. It will just be an open plea in court. I passed on the offer and I'll be real blunt. I've given him ojos that if he gets a lot higher, it's on him, not me, and I'm not going to feel guilty. He said that he wants a trial, so I'm passing it on to the court to get it.
All right, Ms. Ferguson, I need a jury trial date for this as criminal trial division. I need it as early as possible. All right, you're coming back for jury trial on February 6th. Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you'll need to plead open to the court. You'll be brought over dressed for trial in whatever civilian clothing you have at the jail. If you wish to be attired in something different, you'll need to speak to your attorney and do a clothing exchange. If there's an issue with the clothing exchange, let the court know.
Judge, I appreciate it. Thank you for letting me come in today rather than Tuesday. And I'm still going to bet with you on the fact that they're going to cancel court.
You think they're going to cancel the court on that date?
It's not that I would, but you notice certain things like the sun rising in the east and setting on the west. After a while, you notice patterns.
Okay.
Your Honor, may I say something, ma'am?
Sure.
I just want to see if I'll be able to dismissal counsel. I've been incarcerated going on 3 years and I'm still to see yet the discovery pack on any racing arrest.
Oh, you want to see the evidence? State. Can we put him in the box? Counsel, can you let him see the evidence? And if you want another attorney for your jury trial, they need to be ready for trial on February 6th. You understand?
No.
And Judge, just be clear, I don't care one way or another, but if you are going to put someone else on the case, please let me know so I won't.
Oh, no, he's going to have if he wants another attorney, you'll have to hire that attorney. And that attorney needs to be excused. That attorney needs to be ready for jury trial on February 6th. And state, if you'll let him and counsel, if you'll stay so he can see the state trial. Sure. Arturo Lopez.
Yeah. We can have a few more minutes and we just change something on that.
Okay.
Judge, we're ready on ours.
All right. Thank you. John Ray Pettis. Oh, and state. If y'all want to speak with Mr. Contrail about his client who was here the other day.
Oh, yeah. There's a warrant for his arrest now.
Yes.
So he didn't come back yesterday because I was told he did.
Oh, no, I think the person he was with, they came back and stood in the hallway. So he may make an appearance. Court is calling 2022 CR 7826A, State of Texas versus John Ray Pettis. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Michael DeLeon for Mr. Pettis.
And are you Mr. Pettis? All right, everyone, we're on the record, so I'm going to ask that you please whisper. If you cannot whisper, then do not talk while we're on the record. All right, did you review a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision? With your attorney, did you understand it? All right, you're going to have to make sure you speak up.
Yes, Your Honor.
All right. Are you the same John Ray Perez who was placed on deferred adjudication in 2022 CR 7826A for the offense of burglary of a building with intent to commit theft on January 10th, 2023 for a term of 2 years? Is that you?
Yes, Your Honor.
State?
Violated condition number 1, on or about the 8th day of November 2023 in Bear County, Texas. The defendant, John Ray Perez, committed the offense of evade arrest or detention in violation of condition number 1.
How do you plead to that? True or not true?
True. And Your Honor, we waived the other violations alleged in the motion.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
I just wanted one chance to fix my life, but the judge wasn't convinced. A defendant begged the court for probation after admitting to multiple serious crimes, including indecency with a child and fraud-related offenses. He told the judge he finally had a good job, a new home, and his life back on track after years of mistakes. But prosecutors revealed disturbing victim statements, criminal history, and accusations that left the courtroom completely silent. The defendant tried apologizing and claimed he accepted full responsibility for everything, saying he only wanted the opportunity to pay restitution and move forward with his life. But the judge reminded him that no matter how much time passes, actions still have consequences, especially when victims are still suffering years later. Then came the devastating moment. Despite his emotional plea, the judge denied probation and sentenced him to 8 years in prison. Do you think the judge made the right decision?